The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. I am delighted to be joined by Representative Hank Johnson, who is a frequent flyer on this podcast and who, like me, is the top Democrat on the court's subcommittee of the Judiciary Committee. He's got that in the House, and I've got that in the Senate. Like everybody else, we have been looking at the appalling behavior of uniformed agents on the streets of Minneapolis who purport to be doing law enforcement. And we have brought with us to analyze how good of a job they're doing two professors who specialize in this area. Mary Mason is a professor at American University who served for 34 years back in the Department of Justice days. I'm afraid we now refer to it as the department formerly known as Justice, and supervised cases involving police misconduct and is expert in the law related to police conduct and misconduct. And we're also joined by Ed Maguire, professor of criminology and criminal justice at Arizona State University, who has spent more than 30 years studying the relationship of police to communities and violence. And we welcome both of our learned professors to all of this. Professor Maguire, let me start with a question for you. I'm going to read you something that the Minneapolis police chief, Brian O'Hara, said. Chief O'Hara said, and I'm quoting him here, "It looks very untrained. It looks unprofessional. Minneapolis Police Department went the entire year last year, recovering about 900 guns from the street, arresting hundreds and hundreds of violent offenders, and we didn't shoot anyone. This is the second American citizen that's been killed. This is the third shooting within 3 weeks." End quote. You can hear the man's anger and frustration just coming off the page at what he is seeing in his city. What's your general reaction, Professor, to what we're seeing on the streets of Minneapolis and the reaction to it from Chief O'Hara?
Thank you, Senator. Well, first of all, I agree wholeheartedly with the chief's sentiments. And it warms my heart to see a local police chief standing up for his community and standing up for contemporary expectations for how law enforcement ought to be conducted in a democracy. And so I agree with his sentiment. I'm seeing the same things. And I think it's great that we're seeing state and local law enforcement take a stand against overreach by their federal law enforcement counterparts.
And when you say overreach, give us your professional understanding of how what we're seeing on the streets of Minneapolis compares to actual professional law enforcement.
This is not law enforcement in a democracy. This is not how it's done. Law enforcement in a democracy is guided by standards and practices that, there can be some controversy to some extent over what's an appropriate standard or practice, but there's not really a whole lot of controversy over the behaviors that we're seeing and the extent to which they're consistent with generally accepted standards and practices in law enforcement.
They're pretty well accepted, whether you're a state trooper in Arizona or a municipal police officer in Providence, Rhode Island, or a county sheriff in DeKalb County, Georgia. Wherever you are, they're quite well-established standards for how you're supposed to behave in a whole variety of situations. Isn't that the case?
Yes, sir. We have a body of generally accepted standards and practices in law enforcement, and we're seeing those being violated by the federal government on a daily basis.
And the federal government used to come in and enforce those police standards, and now it's the one who's violating them. Let me turn it over to Representative Johnson.
Well, thank you, Senator Whitehouse, for conducting this podcast. There are so many cases that need to be made at this time, one of them being the fact that our law enforcement profession is being sullied and degraded by the unprofessional, incompetent, and cruel policies of these ICE agents and Border Patrol agents who have been unleashed onto the streets of America, occupying cities and terrorizing their citizens, both citizens as well as non-citizens. It's not something that's new to Black America to be under the threat of people under color of state law with badges and guns who are violating our constitutional rights with impunity. That has been a long-standing case, but we must come to grips with the reality that things have been changing for the better in this country. The killing of George Floyd was a watershed moment, and much work has been done by state, local, and federal law enforcement agencies in response to what was seen and what could not be denied. What is your opinion, Professor Maguire, on recent events as relates to the betterment of relations between the law enforcement community and the communities that they work within?
Throughout my career, I've seen law enforcement in the United States take major steps toward improving their relationships with communities, improving the fairness of their behavior, improving their own perceived legitimacy in the eyes of the populace. And in particular, we've seen improvements since the summer of 2020 and the death of George Floyd, and significant reform has taken place in American law enforcement since then. And so what we're seeing now is just a massive step backwards. And when I say backwards, I mean backwards by decades of progress being erased by how we're seeing federal law enforcement officers behave on our streets.
I wouldn't even go as far as to call them federal law enforcement officers. I would call them basically a lightly trained paramilitary group of misfits who are psychologically incapable of being what we refer to as law enforcement. You know, the law enforcement ethos is to protect and serve. But these ICE goons, I'll call them, are coming into our neighborhoods, and they have a more militaristic ethos of break things and occupy and subdue and overcome and overwhelm and oppress, that kind of ethos and mentality. So we have to make the case to distinguish law enforcement from that kind of activity. Would you agree, Professor Mason?
Yeah, I think it's really important that we recognize that this is a problem that we're seeing now with respect to the federal employees involved that really is for folks designated as law enforcement. I was heartened to hear you talk about, the good cops who are out there. There's also really good federal employees more broadly who are trying to do their jobs in very, very difficult times. So what we're seeing now, I wouldn't say exclusively, but it really is a law enforcement problem and a problem with the folks who are now policing or attempting to police or, cosplaying in the guise of police on the Minneapolis streets.
Good word, cosplaying, because it does seem that a lot of their activities are designed not to create safer communities or safer streets or serve and protect, but to create footage for Fox News and for right-wing publicity campaigns that show people behaving very aggressively, very often to people of color, and that suits a particular narrative. So they're actually out there kind of doing video production. And certainly you see folks like Gnome, who is a constant cosplay artist, and that creepy little fellow who they finally ran off, who wore like Nazi-type regalia. He looked like an extra from a bad movie. Now I think they've realized they've gone a bit too far. Professor Maguire, how long do you think the damage will last to law enforcement's reputation, both in terms of the expertise and the discipline and the professionalism that regular police officers bring to the job every day, and to the relationship between those police officers and their communities that so many police officers have worked so hard to improve?
I think the answer depends on how state and local law enforcement leaders communicate with their communities and the decisions that they make. If they make the wise choice to distinguish themselves from the behaviors and actions of their federal colleagues, then I think they can insulate themselves to some extent from the legitimacy problems they're likely to face otherwise. But federal law enforcement, it has harmed its reputation, it has harmed its legitimacy, and it will take years to win it back.
One of the ways that abuse of law enforcement power is constrained is with accountability. And a significant part of that accountability is an injured person having the right to bring a lawsuit to get redress for harm, that very basic constitutional proposition. If you are a state, county, or local law enforcement officer, Professor Mason, what kind of accountability do you face in a courtroom?
So I think there are a variety of kinds. There's the sort of self-policing that Professor Maguire has alluded to, good law enforcement employers doing a good job training their people. There also, for locals and state, is 42 U.S.C. Section 1983, what we call the Civil Rights Act. And that provides...
Which goes back to the original civil rights statutes of 1871.
Absolutely. It is a long-term pillar of how we enforce constitutional rights in our country in that arena. So that does provide a civil damages remedy. Not only, I think it's important to add for state and local law enforcement officers personally, but it also provides some degree of entity liability to municipalities, to police officers. 1983 accomplishes that and has historically accomplished that for a very long time in the arena of state and locals.
Yeah.
It's important to note that in 1871, all the way up to recent times, it's been the state and local law enforcement agencies that have needed to be reined in, and that is why a civil remedy was legislated, giving people the right to sue for monetary damages, state and local officers for violating their civil rights, their constitutional rights. And it was no oversight that the federal government was not included at that time as the target of lawsuits because they were the good guys. But we have seen over the course of time that federal law enforcement officials, many of them have the same mentality of some of the bad apples in state and local law enforcement. And so they need to be sued also. But there was no statutory remedy available to them. So then we came to the Bivens case back in 1971, I believe it was.
Yes, sir.
And
you can teach this class.
Well, it's only because I've been to law school. But no, I give you all of the credit for making sure that we understand these fundamental principles of the law.
What's become of Bivens? It was a Supreme Court decision.
Yeah.
It created a similar regime for law enforcement liability on the federal side to state, local, and municipal. And then what, Professor?
Well, a couple of things happened at Bivens. I mean, when Bivens started out, it was a Supreme Court case, as Congressman Johnson has said. And when it started out, it really was targeted to federal law enforcement officers, principally. Over the years, it expanded beyond that, and the Supreme Court decided that Congress was really in the better position to decide who and when liability should attach. So the Supreme Court started to restrict Bivens and where it might be applicable. And it's important to understand that Bivens didn't simply apply to law enforcement. It applied to all federal employees across the board. It applied, for instance, and cases were brought against TSA screeners, right? Those folks have a hard job. You know, we have 2 million people a day going through airports. So Bivens was extended to a lot of contexts where courts said, wait, if this is what how we want to regulate federal conduct, Congress should really step in. So over the years, the Supreme Court, in cases that I myself handled, cut back on Bivens considerably to the point now where it really provides a remedy in virtually no circumstances.
Yeah, that's the way we see it in my office as well, which is why Congressman Johnson and I, go ahead.
Yeah, you filed the Senate version. I'm carrying the House version of the Bivens Act, which would provide a statutory remedy for agencies to be held accountable for their actions when acting under color of state law. Their employees violate civil rights of people of the United States. That's a very important statutory remedy. Now, we need to go a little further. You know, the Supreme Court giveth and the Supreme Court taketh away. It gave people the right to sue federal agencies and their employees, but over the course of time, it has eroded the ability of folks to be able to recover, to win their case. And so that's the doctrine of qualified immunity, which is a subject for another Making the Case podcast. But I'm proud that we're working together on that, and also the Constitutional Accountability Act, which opens up the agencies that employ these federal employees to responsibility for the actions of their employees.
Yeah, they're two very bizarre situations right now. The idea that the regime of accountability for a law enforcement officer depends upon whether they're federal versus state, local, county, municipal, that just makes no sense. It's a split level in the law that shouldn't matter to an injured person who is the plaintiff, and frankly, it shouldn't matter to the law enforcement officer. The idea that you could be sued for certain conduct if you were a state trooper, but you got away with it because you're a federal agent, I don't think anybody tries to defend against that. The other thing that's a little bit strange about 1983 is that it's usually against the individual officer. So the states and the counties and the municipalities have had to come up with various mechanisms to try to indemnify their police officers. So ultimately, very often, the agency ends up paying the claim, but it's rickety and ramshackle and complex as an operation. And so what this other bill would do is to say, in the same way that if you slip and fall in a Walmart, you don't have to sue the guy with the mop in the Walmart. You just sue Walmart. If the UPS driver drives into your car, you don't have to sue the UPS driver. You just sue UPS. And particularly in police work, that puts the responsibility where it belongs, because so much of what goes wrong in police community interactions has to do with bad hiring, bad training, bad discipline, bad culture, all of things which the agency controls. And so you want the agency to feel directly involved in the litigation, or at least that's my view. Professor Mason, I'd love to hear yours.
First of all, I want to say that I'm a strong proponent of constitutional accountability, and that I think that the existing system or lack of a system does not do a good job in creating incentives for agencies, for individual employers to conform their conduct to the Constitution other than just their own sense of personal right and wrong. And that has proved insufficient. I think we can see that in Minneapolis. So I am a strong proponent in a legislative response to constitutional accountability. With respect to these bills, if you just bear with me for just a minute to take the sort of law school approach, I'd like to compare and contrast them on three important points, okay? The first one is simplicity, right? The Bivens Act is a much more simple, straightforward way to address a problem. It just is a quick legislative fix, and it's easy. What I'll call the Constitutional Accountability Act is a little more ambitious, and it's a little more complicated for that reason. And, you know, people hear federal officers can't be sued in the same way that state officers can, and they think that's unfair.
It
right?
is.
That is unfair. And so the Bivens Act has the advantage of being a simple, straightforward way
Fair.
to approach the problem that seems very fair. The other two important things that distinguish these two bills are, one, their reach. Okay, so the Bivens bill's reach is quite enormous, really, when you think about it, because it opens up federal courts as a cause of action to all the sort of cases that any federal employee might be involved in, not simply law enforcement. So whether it's TSA screeners, whether it's people administering farm aid, and I use these examples because they have been Bivens cases. So the reach of the Bivens Act is quite large, whereas the Constitutional Accountability Act is more narrowly tailored to the law enforcement specific problem that we face. And the third, and I think actually most critical area in which these two bills differ, is that the Bivens Act does not create entity liability in any sort of way. And for a whole lot of arcane reasons that I don't want to get into here, it doesn't waive sovereign immunity of the United States or its agencies. It really simply provides liability for individual officers, whereas the Constitutional Accountability Act takes what I believe is the most important step, and it provides for entity liability, the sort of respondeat superior liability that the senator was mentioning. And I think entity liability is critical for the reasons, actually, that we see in Minneapolis. Whatever we think about the people who pulled the trigger, and I am not defending their conduct in any way, the problem here is not simply a problem of rogue officers going off book, right? The problem here is a problem of agency culture. It is a problem, as the professor said, of how we train, how we approach it. This is an agency that is now devoid, and by this I mean ICE under Homeland Security, that is now devoid of the sort of checks and balances that we've traditionally seen. It is a problem of policy where the government has said, fill these unmoored quotas, right, immigration quotas, and told these officers, many of whom are acting in good faith, to go and do that. Secretary Noem, without any investigation, calls, Good a domestic terrorist, and Mr. Preddy brandishing a weapon, right? These are problems of agency culture. The agency has now endorsed this sort of cowboy conduct, and that problem can only be addressed by entity liability. So I think that the approach that creates entity liability in this sort of way is really a vital component here.
And we hope to get support from police organizations, because when the circumstances that an individual police officer has to be sued under Section 1983, because that's the only way to get the municipality or the county into the courtroom, and they're dependent on being indemnified by the county or the city, that's a tough situation for that police officer, where the real problem is at the agency level, but you got to drag the individual in. So we can clean up a lot with these bills. Professor Maguire, you've been listening to a lot of this. Closing thoughts as we wrap?
Well, I'm a criminologist in a room full of lawyers here, but I do have a couple of thoughts. So one of them is, I'm not a legal scholar, but what I'm seeing on the policing side over the years is that frequently when we see officers behave inappropriately on the streets, like Professor Mason said, it can be traced back to defects in the agency. Typically, we see defects in training, in supervision, in leadership, in policies that in some cases haven't been updated in years and are not aligned with contemporary standards. And so it's really important for us to hold agencies accountable for the behavior of their officers if the agencies are in fact liable. And we often see that to be the case.
I'm struck by the piece of film that precedes the seizure and shooting of Alex Preddy, where you see a woman standing by herself in the street, unarmed, and off-screen rushes a armed federal agent, a man who just comes at her and knocks her off her feet and to the ground. I don't know of a police department where if that happened, if that piece of film came up, that officer would not be disciplined just for that. That's one thing you don't get to do. If you'd lost your temper because she was yelling at you or taking your picture, that's something you just don't get to do. And that's before you get into the horror of watching this young man shot in the back, it seems, 10 different times by 2 officers. Well, thank you very much to our 2 professors for helping us to break this down. If you don't mind, Representative Johnson, I'll turn the last few minutes over to you for any closing thoughts that you may have.
We've been talking today about giving remedies to people whose constitutional and civil rights have been damaged or they've been infringed upon by law enforcement agencies, federal agencies. We've been talking about that. And we've been implicating the fact that these rights would be addressed in court. And so I just want to leave us with this. Our entire judiciary enterprise is funded to the tune of about $9.4 billion per year. But in the big ugly bill, the tax bill that Republicans passed last year, they gave ICE, an agency of the Department of Homeland Security, $75 billion. So they've got more money at ICE than they can shake a stick at, and they've been using it to advertise for a 10,000 agent plus-up at ICE. They've been advertising on right-wing, reactionary mediums. They've been disseminating racist ads that attract racists into ICE, and then they fail to train them adequately, and then Stephen Miller tells them that they have absolute immunity for whatever they do on the streets. And so they then send them out like a pack of wolves, and they act like a pack of wolves when they get out on the streets. This is our reality. How should we hold them accountable? Each agent, each rogue agent needs to be held accountable, but it's more important to get at the people at the top, get at the agency itself, which is responsible for creating the culture within which these wolves operate. And that's what these 2 pieces of legislation would do, the Bivens Act and the Constitutional Accountability Act. And I'm proud to be sponsoring both acts as your partner in the House, Senator Whitehouse, and I'll kick it back to you.
Thanks, Representative Johnson. I've never been a police officer. I've worked with police for many, many years. But what I have been is the chief law enforcement officer of the state of Rhode Island and the United States Attorney for the state of Rhode Island. So I have held those law enforcement press conferences in ongoing law enforcement matters. And if there's one thing that is a primary obligation of someone in that circumstance, it is to tell the truth. People need to know what is going on, and they need to get a message from the top of the organization that the truth is what will be told. And so, as appalling as so much of this street-level police, I take that back, police-style misconduct has been, watching the secretary just flat out lie about what was taking place on the streets, I think that sent also a terrible, terrible signal. We will try to make sure that making the case tells you the truth. Thank you for listening in. Thank you to Professor Maguire and Professor Mason for participating. And thank you to my friend, Representative Johnson, for all your good work. That ends this episode of Making the Case.